Thank you so much, Alain. Folks, thanks so much for coming out today. I'd like to introduce you to my colleague, Andras Burkus.
Hi, everybody.
Andras and I are both portfolio managers with RBC Dominion Securities, and Claudia Morrison, who is our guest speaker today, is part of our team, and she helps our clients with the discussion of creating their estate plan. So what you're going to be seeing and hearing today in the webinar is what we go through with our clients whenever we review their estate plans. On to some more housekeeping notes. As Alain said, there will be a link dropped in for an evaluation form. So if you'd like to receive a copy of the content of today's seminar, please note that. If you have any questions that don't get answered, by all means, jot it down. And if you're interested in the name of any bilingual estate planning lawyers, estate lawyers, we'd be happy to provide you with those names as well. And finally, as part of the National Association of Federal Retirees, we also offer to do a 1-hour complimentary Zoom meeting with you to review your estate plan and financial plan. We've been doing those for the past couple of years with the members, and it's been very popular. It's part of the benefit of being a part of the association. So without any more time wasted, let's put this on to Claudia to start the presentation. So I'll just share my screen on that one.
Thank you and good afternoon. Welcome everyone. Really looking forward to spending the next little bit of the afternoon with you, and thank you for joining us today. So we're going to be talking about the fundamentals of estate planning. So we're going to be touching on wills and powers of attorney, but I'd like to just start off first of all with what is an estate plan? So often I do meet with clients and they think, oh, I've got my will, I've got my power of attorney, I have an estate plan. And I would just like to spend a little bit of time just focusing on the idea that actually an estate plan is a bit more comprehensive than that. It's really about the process of organizing your assets, looking at what you have, what are your wishes about passing that on to the next generation, and what can you do today to both preserve assets, preserve your wealth, look at what is the tax liability, what's the tax planning of various strategies, looking at all these things that are listed here, things such as life insurance. If you're married and have a spouse, what is a spousal rollover? How does that impact things? Beneficiary designations are key, and we'll be talking about that a little bit further. More complex planning certainly is an estate freeze and would be beyond the scope of this presentation, but I certainly am able to speak to that. And of course, your retirement plan. When we look at preserving your estate, we also want to look at actually protecting that legacy. So an effective estate plan really should include a number of things. I always encourage people to look at what is your current situation. Think about worst case scenario, what would happen in 6 months, a year from now? Is everything organized so that if something does happen, the right things or your wishes are going to take place? The estate plan should really also then look at what do I have and how can I transfer that in the most appropriate manner. So in cases of your will, if something happens to you, pass away, there's really two choices about how to pass things on to your beneficiaries, those people that are important to you. You can give things directly to them, so that's called outright, or you can create, in the wording in your will, a trust, called a testamentary trust, and that type of structure is really based on the needs of the beneficiary. So if you have minor children or grandchildren, if you've got beneficiaries with special needs, sometimes blended families, this use of a trust is a vehicle to transfer the assets you have today to the beneficiaries that you wish to receive their inheritance. We also want to look at maximizing the value of your estate. And so that is paying close attention to costs, which certainly include probate taxes and income tax. The other thing that we want to make sure about is when you have an effective estate plan, you really are then planning for those unexpected events. We all do, unfortunately, know we will pass. We just obviously don't know when. So with that in mind, and also with the idea that we don't know whether we will lose capacity, it's really important to plan. And so who are my contingent beneficiaries? Who have I put in place when this unexpected event happens? And of course, powers of attorney. I like using this Spiderweb as an analogy. to talk about your will and powers of attorney. So you can see sort of at 12 o'clock and 6 o'clock, if this were a clock, we talk about will, power of attorney. So the analogy is such that you see here a spider web. You see all around these different titles. I call them components. So things like income tax planning, designations, etc. So a number of these components may play a role in your estate plan. Some may not. If they don't, then you can just ignore them. I think what I'd like to highlight about this is to put in this in frame it with the Spiderweb in mind, to say, if you don't properly deal with one of these components, or if you've made a decision with regards to one of these components, they can very much alter the shape of your estate plan, or could decimate it. So just like if we're trying to do some house cleaning and you find a web, if you touch it, the web will move or change shape. Sometimes you can sweep that cobweb right out of existence. So it's really important to just look at these different components, understand whether they're relevant, what are the choices around them, and how do they impact your overall plan. Now, when we look at the effective estate plan, we're boiling it down to what we call the cornerstones, so will and powers of attorney. So a will is a document that you create. It's a legal document. We definitely recommend that it's created with the help of a lawyer. So again, it's a legal document where you, as the creator of the document, or the person called the testator, states in this who you're going to name to be in charge of your estate administration, and to whom do you wish to gift what you have. So the will comes into effect only once you pass away. A power of attorney document, I'll be going into that momentarily, but this is also another legal document, and it is where you, as what we call the donor, so you're the person in charge, and you're giving somebody else authority over your decisions with regards to personal care and or property. We're going to look a little bit at what happens when you don't have a will or power of attorney. So in some cases, I meet clients who either have a very, very old will or none at all. So for the purposes of this, if you do not have a will, what does that mean? So within this scope of Ontario, so we're dealing with common law in Ontario at this moment, if you pass away without a will, essentially that means that you have not picked someone to be your executor, nor have you coordinated with anyone or anyhow how you wish your assets to move or be transferred to someone else. So what ends up happening is that the provincial intest succession legislation ends up making the decision as to whom will your estate now pass. So clearly you haven't worked your entire life to now have legislation dictate who your beneficiaries are going to be. So we encourage to make sure you have your will, that it's a valid will as well. Powers of attorney, same kind of concept. If you do not have these, then should you lose capacity, then you do not have someone that's going to be making decisions for your personal care needs and or your property. So that also causes significant issues, because then you don't have anybody that's representing your wishes, your values, etc. And largely then somebody would need to be appointed by the courts to be able to make decisions. When we look at the types of powers of attorney, we're really looking at these two. The first, we're going to talk about powers of attorney for property. So this document, and I do recommend that you have two separate documents. So each is a separate legal document, where power of attorney, you're going to name someone an attorney, and the scope of responsibilities is really all matters or all decisions that pertain to property, your financial assets, investments, etc. I want to make clear that there's really two types of attorney for property documents. You can have a specific power of attorney document, such as if you're out of country and you need to close on the sale of a property, very specific event, you're not here, you want somebody else to sign off on the papers. When we talk about powers of attorney with regards to incapacity, you would be making this document while you have capacity, but it's really important that these two words, one of these two, enduring or continuing power of attorney, is in the document. And the reason for this is that the document then means that this power of attorney document can be used when or if you lose capacity. So you've made it while you have capacity, but it's valid to be in force after you lose capacity. With regards to powers of attorney for personal care, the scope of the decisions with regards to the person you've named in this one are all around around the person. So those are healthcare needs, medication, where one might need to live. Does the individual, can they stay at home with home care, or do they need to move to a residence? And of course, also end of life decisions would be part of the role that an attorney for health would carry out. With regards to royal trusts, so we're a trust company within RBC, we can certainly be named as your attorney for property. However, we cannot act and or assist you with your power of attorney for personal care. We often look at who can be an attorney. So you're there trying to create your power of attorney, thinking who around me would make a good attorney. So from an age perspective, anybody over the age of 18 can act as your attorney for property, and anybody over the age of 16 can actually act and make personal care decisions for you. You can name a person, or you can also name a trust company to then be appointed in this document and be what we call your substitute decision maker. How many people? So often I get a question as to who can act, how many. So anybody that you trust, you can name. You can name them to act on their own. So that would be sole, to act together. So that's sometimes referred to as a co-power of attorney, or jointly. And often, or sometimes, not always, I guess, we see the wording jointly and severally. So this pertains really only to power of attorney for property. And that means that you have the ability to name two people. They might not live in the same city, but you are, when you say jointly and severally, then one person can make a decision without the authority or agreement with the other. And so that also could lead to some trouble where one of your attorneys makes one decision and then the other one doesn't really like the decision and in fact turns around and unwinds that. So really important to think about who you're naming in this case, of course. When can somebody act? So we have two different really types of documents that I generally see. So if you're drafting it with your lawyer, it's important to think of, and the lawyer would also perhaps ask you, once you create this document, what's your expectation around when can the person that you're naming act on your behalf? So a lot of documents I see, there is nothing that stipulates when this event happens. So we call that, it's immediately active. So that doesn't mean that if they have, technically, I guess, if somebody got a hold of your document, they could run around and make decisions on your behalf. But in most cases, we're seeing, especially, unfortunately, with some abuses of this power, you're seeing lawyers drafting that there's a triggering event. So in the document, your power of attorney for property document, it will state that this document is only valid once I've been assessed by a medical professional that deems that you are now incapable, or it could be a bit of what we call a hybrid. So the document itself, the wording itself would show that it is immediately active. However, there's a letter that goes on top of it that states that the lawyer is going to have to release this document before it becomes active. The one thing before we really go on to some other aspects of this is to just be mindful that when you name someone to act as your attorney for property, they effectively step into your shoes, which means that they can make any decision with regards to your property except make a will. So this leads us nicely into duties and responsibilities. As you can see, there's a host of them here. So essentially, when you think of, if I'm incapable, I've named this person, what are they going to do? They're going to be dealing with your family. They're going to have to pay bills, collect income. So if you have various streams of income, pension income, RIF income, whatever, they generally, an attorney will create a power of attorney account and then redirect all streams of income into that account. They certainly need to manage and safeguard those assets. So whether that's real property, real estate, or investments, they're going to then be responsible for the investments that you have, whether that's a TFSA, RSP, RIF, non-registered investments, bank accounts, etc. But it is generally what we call a consolidation event. So in order to make the role easier for the attorney can often, or certainly has the power to move all assets to one financial institution in order to make their job easier. It's really important for the attorney to keep detailed records of the transactions, just because they potentially will be held to account for those decisions and actions by then the executor at a later date. One thing I do want to make very, very clear is that if you're acting as an attorney, or when you're thinking about your attorney, they must only act for the benefit of the person who's incapable. So if someone's acting as an attorney, any decision that they must make with regards to care or spending your assets, it must be for the benefit of the donor. So we're now going to be moving into wills, executors, and the role of the executor for the rest of this presentation. So to start us off here, I'm going to just list and go through a number of wills that exist. So a formal will, the best type of will you can get, I definitely recommend that you meet with a lawyer. If you're in Ontario, a notary if you're in Quebec. And so a formal will is one that's drafted by a lawyer. They take your instructions, create this document. It is signed by you, initialed at the bottom of each page. And also there are two witnesses that would also do the same. So they would witness each page and then sign beside you, witnessing to the fact that you have now created this document. It would be important that the people that you've selected as witnesses are not named as beneficiaries in your will. With regards to Quebec, so the majority of this presentation will deal with common law, so Ontario law. However, we're not, we're just across the border from Quebec, so that often does become very relevant. So in Quebec, there's a different system of laws you may be aware. It's called the Civil Code versus Ontario common law. And how residents of Quebec can make a will, things are just a little bit different, done differently. So it's called a notarial will. Individuals would meet with a notary, and then the notary would draft the document. And in Quebec, interestingly, when you create this document, it is then housed or sits in a central registry. It's called the Chambre de Notaire. So in Quebec, everybody knows where the last will and testament is of this person. The notarial will sits in this central registry. So if you make a new one, you take the old one out, you exchange, and everybody knows where it is. Unfortunately, we don't have that system in Ontario. The other form of will is called holographic. So I want to be clear, a holographic is a valid will from the point of view of it can be deemed valid. Often there are a lot of problems with a holographic will. So what is that? That is a will that's drafted by the person in their own handwriting alone. It is not witnessed by anybody, not signed by anybody. If it is, so if you do make one of these and you have somebody initial and sign it, it basically negates the entire document. So as you can see, most people don't know the laws and rules around making wills. And so there's often really unfortunate drafting errors where then intestacies are created. So it's as if you don't even have a will. So we strongly urge you not to make these types of wills. We have then the next one, DIY, which is do it yourself. I certainly call it the dreaded will kit. So this is a document that you can pull off the internet. So it's a document that you have in front of you, either online or printed, and parts of it then have words typewritten. And so you either typewrite in it or the relevant material or information, or it's in your own handwriting. So now this document is a bit of a hybrid between handwritten wording and typewritten wording, again, still all in your penmanship and or signed. We've seen in many cases where these are used that, again, they're deficient, that assets aren't dealt with, and therefore then whatever that holding or asset is of the deceased is dealt with as if the person didn't even have a will. So again, some real issues can arise, so strongly recommend you don't go that way. In Ontario specifically, if you have a private company, so if you have a holding company, whether that's an investment holding company or an active operating company, you have a strategy in Ontario where you can have two separate wills. And the purpose of this specifically is to align certain holdings or assets that you have between your primary will, which would reflect the wishes with regards to your personally held assets, so assets in your own name. And then the secondary, or often called corporate will, would deal with the disbursement or administration and disbursement of privately held corporate shares or other things like art or valuables. So sometimes we've seen individuals with large art collections or jewelry. And so again, there's benefits to this strategy where this value of the assets that are listed in your secondary will avoid something called probate. And we'll be moving into that very shortly. So just quickly, when you're thinking about making a will, as part of making your plan effective, it's really important to review the composition of your assets. So looking at, here it says inside your estate, outside your estate. So as many of you know, you can hold obviously money in your own name. It can also be held jointly with someone else. When you hold accounts joint with right of survivorship, the feature of that is that when one person passes, the value of that property or account now transfers and becomes the property of the other account holder. The same feature is evident in things like RSPs, RIFs, tax-free savings accounts, insurance policies, where you name specifically an individual that you intend to receive that. So when we look at in what bucket do various assets go when somebody's managing your estate, what is flows according to the terms of your will would be all those that are the in bucket over on the left. So those are probatable assets, assets in your name, whereas the assets or structures that you hold to the right, they do not flow according to the terms of the will. So I always make sure that to remind people to make sure that when you're changing your beneficiaries, sometimes there's life events that cause you to reflect and say, oh, I should update my beneficiaries. Always go back to your will and make sure that those two are aligned, that the intentions do speak similarly. We're going to see in the next couple of slides all the things an executor does have to do. So this is sort of putting a bit of a light to say, what kind of characteristics would be important in an executor? So when you think of, I'm going to pass away and I'm going to name someone, and are they the right person to do this job? So you'd want to think of things such as, what kind of financial judgment do they have that you're aware of? Where do they live? We certainly recommend that if you live in Ontario or Quebec for that matter, and you name someone who does not live in Canada as your executor, please come and talk to us. We strongly urge you to get legal advice around that. There are some significant issues, both with gaining probate and also income tax that arise if you have what we call a non-resident executor. The fact that they may not live in the same city or province also causes issues. Clearly looking at, how organized are they? How do they manage many aspects? How do they delegate? What age and stage are they? Are they retired? Where, what are they doing? Do they have a family with young kids? That kind of thing will play a role in their ability to now do all of these other things. One of the things that certainly does arise is sometimes when you look at who your executor is within your family structure, is there a potential for bias? Is there a potential for conflict of interest because of the position you've put them in? Then also that could just cause some friction in the family, whether it's an individual, whether it's the eldest son or daughter, whoever it is. Just be mindful that sometimes through no fault of anybody's, just it can cause some friction. There may be disharmony in your family for whatever reason, or after you've passed away, just the way the family left behind is managing through grief and or managing through all of these different tasks. We do often see, unfortunately, that friction arises, and that can cause some issues for everyone. Clearly knowing what to do, understanding all of the duties is key. The executor has the ability and right to hire or retain people, so they can lean on an accountant, a lawyer, trust company to assist them with their duties and responsibilities. When we look at the word executor, so executor is sort of the more common term. In Ontario, we refer to the executor as the estate trustee. In Ontario, we have a bunch of words for a number of different things. So for right now in Ontario, the executor is called an estate trustee. And what is that? That is an individual, can also be a trust company. You can name one or more than one. So you can name somebody as a sole executor or estate trustee, a co, or alternate. So you name one person, and if you think, well, that person, what happens if they pass away or become incapable? Who's my next best executor? And that would be then naming your alternate executor. And they're responsible for administering your estate. So they are charged with the duty of carrying out your wishes, but also abiding by the laws of the province to make sure that the entire administration is done properly. So according to the provincial laws. So one of the things that, not in every case, but in many cases, the will that the executor has been named in must be probated or brought to the courts. And in Ontario, then what you get is called a certificate of estate trustee with a will. That's more commonly known as a grant of probate or a probated will. In Quebec, I'd mentioned before, they don't have this process where the will needs to be validated because the will sits in this central registry. And the terminology in Quebec is that you would appoint a liquidator. I like using this slide. I'm kind of visual, so I find this one is a good depiction of all the things that an executor has to encounter. So over to the right, you see if it's an individual that you've named, they have a family. Maybe they have young kids, or maybe they've got take care of their parents, or maybe they're seniors where they have to work. So again, being mindful what is happening in that person's personal life. The executor, if you look up to the top, needs to deal with the beneficiaries. If there's a business, so if the person who's passed away owns a corporation, if it's an investment corporation, if it's an active business, the executor steps into the shoes and has to become either an officer of that corporation or is now running that business. And over to the left are a number of the third parties that an executor would have to contact, deal with in order to carry out the administration. Down along the bottom, you'll see these 7 different steps. They're not really, I don't like calling them steps, they're more buckets because as an executor, it is not sequential at all that you would move 1 through 7. You often find that you're moving between any one of these steps. And we're going to now move into these more specifically. We start off now as an executor. What are they responsible? The preliminary steps of an executor would be obviously to locate the will. So important that whoever you've named, let them know. Most likely, they're also going to be engaged in the funeral arrangements. As an executor, they would be the person signing off on whether someone is cremated or not. The funeral home wants to be certain as to that decision. Then, of course, through the funeral home, obtaining a number of death certificates. The will is obviously reviewed, and you're going to identify, the executor is now going to identify the beneficiaries. What type of beneficiaries are there? Are they getting a one-time gift? So that's called the legatee, or are they going to get a percentage of residue? So you'd identify who they are. Sometimes, of course, the person who's passed away has a pet. Sometimes the will does name someone that you request that this individual take on your pet. If not, then certainly the executor is responsible for making arrangements and taking that pet in, or finding somebody who can. Sometimes we do see, depending on what the family structure is and who the person is that's passed away relative to this family, sometimes it's a surviving spouse or other people that might be dependent on the person who's passed. So there might be financial needs that are important to review. In this day and age, we do see blended families, so second marriages, etc., or even common law relationships after a relationship has ended. And that also does lend itself to seeing marriage contracts, or you see cohabitation agreements, or if there's a division or a dissolution, I should say, of a marriage, then there are family law issues with regards to separation agreements. So if there are any of these types of things, the executor actually becomes responsible for understanding the impact of any kind of legal obligations that the deceased had to anyone else. Now, I did mention just a wee bit ago about probating the will. So for this purpose, so I would say that if you are a couple or you're 2 people living together and you've named each other as the executor, and the first of you were to pass away, in many cases, the first person passing away doesn't need to probate the will, but it's really then the second estate that needs to get probated. That is really the process of going through the courts, where the court validates now this document as the valid will. And also then the executor must pay something called estate administration tax or probate tax. And in Ontario, that's 1.5% on the gross value of the estate. Clearly, figuring out who the beneficiaries are and understanding the relationships that you might have personally with these individuals. I would say that one of the things where an executor who's a personal executor and a family might have increased friction is if there's a lack of communication. So as an executor, it is your duty to communicate to beneficiaries, and it's certainly the right of the beneficiaries that they receive constant and regular communications. They would receive something like something called a copy of an estate summary, which is a listing of all of the assets of the deceased valued as at date of death. And so they would need to, the executor must continue to account and to communicate with these residual beneficiaries. So beneficiaries that are getting a percentage of the estate. Safeguarding the assets, clearly really important. You'd need to open an estate account, looking at insurance. So this might be anything from life insurance, but also insuring the property. If there's a home, you must call the insurance company and advise them of the passing and make sure that your home insurance is valid and covers the circumstances. You're going to really, in the initial stages, you've presented the will to the courts for this probate process, and in the meantime, you really can't do much because the third parties that you deal with will require this certificate before they release any assets to you. So you're really spending the first number of months notifying, doing a bunch of notifications to bank accounts, to Service Canada, to wherever the person was dealing, canceling and returning credit cards, things like your passport, air miles account, all those types of things, digital assets, clearly emails. If you know the digital assets is a whole sector now, and we do have a piece on that we happy to send to you. The other thing that we do mention is that you notify the credit bureaus, Equifax and TransUnion, that the person who's passed away, notified that the SIN is number tied to the deceased is now deceased. And we've seen a case where actually somebody had tried to take out debt after the person passed away. Valuing the asset, this is the key part. So while safeguarding and maximizing the value of the estate, you also want to figure out, how do I value this? So clearly bank accounts or investments that they hold at financial institutions can be done through statements, but things like real estate, you would have third parties appraise both the contents of the home and also real estate. If business, etc., so there might be a business valuation. And essentially, you're going to then take the gross value of the estate and pay probate on that, let the residual beneficiaries understand that, and then you're going to pay debts. Moving to administration, there's a whole host of things. I'm not going to run through all of these, but essentially as an executor, you now have to deal with many pieces of paper. Anything that the deceased was involved in, you now are responsible to tidy up all of these different aspects. So you're going to deal with, as you can see here, dealing with CRA, CPP, pensions, etc., and of course paying any debts. Taxes is a big one. There's two types of tax returns if the person doesn't have a corporation. So there's the tax return in the year of passing that generally is very heavy with tax owing. So that's from the period is January 1 to date of death. And then there's the estate tax return, the T3, which is from the period of date of death forward. So these tax returns must be filed. They're the obligation of the executor. They can certainly hire an accountant. And once those tax returns have been filed, notices of assessment received, and if there are any corporate filings that are required, then eventually the executor would want to and should be obtaining what's called a tax clearance certificate from Revenue Canada. The last bucket or piece that I'm going to talk about is called distribution. So as I said, through all of this process, you're going to figure out where the assets, in many cases, Some assets are distributed directly or in kind. Others must be liquidated, and then cash is then transferred to the beneficiaries. It's important as an executor that you keep track of your expenses and any expenses, because you're going to have to account to the beneficiaries. Once you do have your clearance certificate, then you would move to doing a final distribution. We always recommend that you, as an executor, you do at least 2 or 3 distributions throughout the administration, always mindful to keep money back until you have this final clearance certificate. And we certainly recommend that as an executor, you then reach out to the beneficiaries that you've been dealing with, and you get them to sign off on your accounting. So it's a form of indemnification for the work that you've done. And then you're really in a position that you can close out the estate account. The executor should always recommend that any beneficiaries receiving an inheritance do get some professional advice. So we've covered quite a few topics, but also a number of items as being an executor. So as a summary, I would want to leave you with a couple of thoughts. One is, please make sure that your will is up to date. Please review who have you named as your executor, and do you feel that they're the right person for this job? Same goes with powers of attorney, both for property and for personal care. And have you, who have you named, and are they the right person? Making sure that your beneficiary designations are up to date and align with your will. And then just make sure that periodically you review your whole plan. So all of the things we chatted about today. And please reach out to us. We're happy to continue to help and provide some level of guidance within Royal Trust. We certainly do have support for people who are executors when they are acting in the role, or certainly if you're interested in naming Royal Trust in your own personal wills and powers of attorney. We're happy to talk to you about that, just so that you're aware of the types of support that you do have in moving forward and making sure you have an effective and comprehensive estate plan.